The broadcast is now starting. All attendees are in listen-only mode.
Good morning, everyone. Thank you for joining us today. This webinar, Legal Update, will now begin. Welcome, Dr. Gordon, Dr. Rowan, and Ron McDonald.
Good morning, everyone. Today is a day that will change your life. All you have to do is take careful attention to everything we're going to tell you. Last night, PBS had Bill Moyer on, and he interviewed this gentleman, Mark Leibovich, and what they said would so shock you that I immediately went and got the Kindle version of the book for $11. They have shown how corrupt beyond belief Washington, D.C. has come. And essentially, the last thing that Bill Moyer said, I can't paraphrase it, but he said he would be amazed if they don't come and pull and take that Washington, D.C. apart brick by brick. What we're going to tell you today is we can have a complete change and cut the head of the beast off, and not a single shot needs to be fired. If you will take the time to listen carefully to what Dr. Robert Rowan and Ronald McDonald have done with 10 years of diligent research to find a legal, lawful way that will change immediately if you choose to learn everything, how many taxes you pay, and that will cut the head of the beast off. And that means that the corruption, because when you hear the story Mark Leibovich told on PBS, and of course it was much more powerful there probably than just a book, which is about 400 pages, carefully documented, but he was with New York Times, and he knows every one of the politicians, and he knows how every one of them have stabbed us in the back, and he has the goods on them. But because it was on the PBS, if you choose to go there and buy, they have the clips of these guys telling their little lies, so they have the whole story. So the exciting thing is that you're going to learn today that having started with a very diligent effort that there had to be an answer to bring the Constitution back, empower you again, give you the freedom you need to treat patients without your medical board giving you trouble, to bring down the amount of taxes that we are sending to the beast. All of that is possible, as you will learn today, that there is a writ that is a masterful piece of work, and it will actually be filed with every Supreme Court in this country, and it will cause the states to go back and honor their Constitution, which makes Federal Reserve notes meaningless and fraudulent in all business transactions. It can bring the money back and save America and bring us back. So with nothing more said, I'm turning it over to Ronald McDonald and Dr. Robert Rowan, and we are here because I'm going to pitch in during his comments to make sure you get the punch of what we felt when we were at the meeting in San Francisco. The people who were in that meeting left there, and I've sent many of you the testimonials from every attendee, so you can rest assured that if you decide to help us save this nation without firing a shot and come to the next chance to have a 2-day workshop and see the documents that actually show in black and white that the government doesn't know what to do when you start dealing in gold coins, and it's going to change your tax status in ways you have never dreamed. Because I've seen the documents, I can tell you everything is real, but I do think we have to honor the tons of work, 10 years nonstop, that these two gentlemen have put together to give us a way out that no one else has seen. And if we get this information in the hands of people like Ted Cruz and Rand Paul, these people who are calling for the abolition of the IRS don't know that we have a way to do it. And there is no way Washington, D.C. can do it. When you read this book and you hear what Moyer said last night, the game is to never do anything because they make money by milking the system. The Congress has no incentive to change anything. So thank you for attending. We're going to take a lot of time today because this is the last document that will be really available for you and your friends to learn why you want to be at ACAM in Palm Springs so that you are there for the 2 days before the regular meeting and have the chance to learn what these two gentlemen showed and delivered to the attendees that will give you the freedom to stop your medical board from using hearsay evidence in how you can move, if they're moving against you, how you can take it to court. We covered things that would change your life. So thank you. Ron, thank you for being here.
You're quite welcome, Dr. Gordon. Robert, did you want to discuss certain things? First of all, maybe the medical issue?
Yeah, there's a lot of doctors on the call, I'm sure, and I do welcome anybody to send us a message so that we can address it during the webinar. There's two key issues that we want to discuss that we have been discussing. The first is with regard to medical doctors. Everybody is scared out of their pants with regard to medical boards and licensing agencies. And I think Gary will confirm for the audience that we provided irrefutable law, case law, that's good law, that shows that the medical boards are currently operating beyond the police powers of the state. And that we showed at the seminar, and in fact we had somebody there from Washington who gave us accolades in a review. He said, despite the cost, he said it was a bargain. Washington state doctors are being wiped out one by one right now, and it's happening because the doctors are allowing themselves to go through a regulatory agency process where they don't have their full due process rights. And we showed irrefutable case law that the police power of the state is very limited in this respect, but nobody has done it correctly, so they're getting totally wiped out. We will be showing you at the ACAM seminar the means to defend yourself and actually take an extremely aggressive position against the medical board and any agency that might come against you. Did I put that in the proper words, Ron?
Yes, you did. And there was also an attorney there at the seminar that once he heard the process, the procedure on how to stop the agencies from moving against an individual, he was blown away. He says, my God, I did not know that we had that avenue to proceed in.
That's absolutely true. That attorney, I know him personally. He's actually a patient, and he told me this week, he said, I was absolutely shocked that we have the ability to stop a regulatory agency in its tracks because of due process.
And one of the things that when you go through an administrative hearing, they're allowed, administrative boards are allowed to hear hearsay evidence against you. That in itself will destroy you. You cannot win against hearsay evidence because you cannot prove a negative. You cannot defend against a negative. So that's what we show at the seminar, how to defend yourself and stop the hearsay from moving against you, that evidence.
Now, one of the other things that I wanted to point out before we start with this writ, and for the audience, what we're presenting today is what we believe is the answer of 90% of the horror that's befalling the nation today. I mean, it's sort of like most of you are integrative physicians. You know, if you find the cause of a problem, like a bad root canal that's infected, or some interference in the body, and you take care of that, almost everything else is going to fall into place. You're going to have to do some mop-up. The issue in this country, more than anything else, is the currency, because we're using property. What's in your wallet and your purses now does not belong to you. It's a Federal Reserve note. It is property of the banking system, the international cartel called the Federal Reserve System. It belongs to them. And because you're using their property, you are subject to draconian rules and regulations. And they can print this stuff out of thin air. They can wipe you out with an entry in a computer. You could have $1 million in the bank and they just double the money supply. You've lost 50% of what you think you have, but you don't even have it because you don't own it. It's not yours. And we showed that in previous webinars, and we showed that at our seminar, and we will show it again. What we have today which is what Ron is going to go through, is a remedy to bring back the monetary system to a constitutional monetary system. And when that happens, and we need your help, when that happens, we've remedied 90% of the situation. As background for you, I took a case all the way to the United States Supreme Court. It was in 2004. With Ron's help, I was the first person since 1933 to actually get a lawful gold coin into a federal court, and they didn't know what to do with it. They couldn't see it. It didn't exist. This went all the way to the Supreme Court, and we told the Supreme Court in a writ of certiorari that if you don't grant this writ, you're going to be telling the people of the country that lawful money, $5, $10, $20 pre-1933 gold coins, cannot be seen in the payment of debt. You can't see it. And guess what they did? They denied the writ. They denied the certiorari, meaning they sustained the lower court's decision that lawful money, the gold coin, doesn't have monetary value. Now we have paper after paper after paper from both the IRS and the California Franchise Tax Board attesting to the same. Gary, will you agree to that?
Absolutely, and it's so powerful because it means that should your patient decide to pay you with one of these worthless gold coins that are the pre-1933 United States gold coins, that technically, since they can't see it, you can report it and say, I was paid with a gold coin, and they will not have a way to tax you because they cannot recognize it, because to recognize it opens up Pandora's box for them and does what we're about to do with your help when we get to Supreme Courts of every state to help us recognize this simple problem. The Federal Reserve notes are not money, and therefore the actions that they do when they confiscate your property are fraudulent.
I should say that the certiorari, when we filed it into the Supreme Court of the United States, we wanted them to deny it, because in denying it, they would have reaffirmed the lower court's decision in what gold coin is, and that is it has no value, if any.
Now, also, for the listener, what it's saying is that the court you're walking into is not a real court of the United States. It's a court that's in international commerce using international commercial instruments called Federal Reserve notes. These are debt notes that have value only to them. They cannot see real money. It doesn't exist. And I have that directly from the court, from the Supreme Court, from the Federal District Court, from the California Franchise Tax Board, and another California taxing agency called the Employment Development Department. None of them can see the gold coin, and they returned it. Think about that for your pocketbook and your life and your livelihood. If you want to have something for the future, these agencies can't see it. They might tell you that you have a tax if you report a tax to them, and we're not here to teach taxation, but if you try to pay them in gold, they'll return it. Hello. Now, we probably should go to the writ now so they can see the ultimate remedy, and then we can field some questions.
Okay, the writ that's being presented, I'm hearing an echo in the background too. The writ that's being presented deals with the recorder of the counties, of every county in the United States, and the sheriffs of each of those counties. And it's against them for, it's a prohibition against them for receiving federal instruments. Now, federal instruments are instruments that are pushed into the recorder to attach to properties or to seize properties or things of that nature. So what we're doing, and this is an in-state act, it has nothing to do with the federal jurisdiction, is to do a writ of mandamus and prohibition to compel these public officers to follow their duties. Now, the writ of prohibition is to prohibit an act that a public officer may be doing, and the mandamus is to compel the duty to be performed. So if you understand that, we'll start the webinar on this aspect of it. Okay, what this writ may accomplish. Restoration of honest money. Since 1968, we have not had honest money. In 68 was the last of the silver certificates that were printed by the United States or Federal Reserve and used by the United States. At that point, all value to the legal tender had collapsed. We have worthless instruments floating around. It would also do an end to the current version of the federal income tax based on unlawful currency. Well, if the currency itself does not apply lawfully to the 16th Amendment, the taxing amendment, the income tax, then anything built on top of it, any liens, any levies, anything of that nature, anything that the federal government can produce on top of those unlawful notes would be unlawful, because the maxim says if the foundation is not lawful, nothing lawful may be built atop. Okay, thirdly, an end to runaway government, which, if there is honest money, will have to live within its means and delegated powers. When we shut the door of the recorders, and that's precisely what we're going to do, shut the doors of every recorder through every county of the country, we're going to prevent the federal government from moving against individuals, and we're going to push it back into a container where it belongs. We're going to stop feeding the beast, in a sense.
Ron, if I might elaborate on that, the portal of entry of the federales to get you to destroy your life is to file a federal instrument which you might better know as a lien against you. If the lien cannot be filed at your county recorder, that's the portal of entry, they don't have any means to grab anything of yours. Is that correct, Ron?
That's correct. That's the only means by which they may move in and attack citizens is through that doorway, through the recorder's office.
So
There's no other means.
If that is closed to them, and the people of this country know that it's closed to them, and that it's closed because of the dishonest monetary system, then you can imagine what will happen with the people with regard to them continuing to feed the beast until the currency is redeemable, as you will see the court has mandated. And that will also end the destruction of our liberties and freedoms, what few freedoms we have left.
So I want to make it clear that this is not a federal issue that we're pursuing. It is a state issue. The writ basically is commanding public officers of the state, of every state, to perform their duties in accordance with the supreme law as interpreted by the Supreme Court of the United States. So we're just doing in-house, an in-house issue. We're not moving against the federal government. We're not moving against the Federal Reserve notes. We're not moving against the income tax. We're basically compelling our officers to uphold the law. Okay, fourth, an end to destruction of our liberties and freedoms. That will be stopped once we stop the door, once we stop the federal government at the door of our state. Okay, let's go next.
Just press send, Ron.
I did, and nothing happened. Okay, how? Okay, how? We will subsequently show how the current currency can be applicable to the 16th Amendment, which authorized an unapportioned income tax. 2, if not applicable, the writ will prohibit the recording of any federal instrument upon anyone else until the currency becomes redeemable. Now, that's one of the goals, is that we close the door to the federal government until such time those notes are redeemable. Then the door will be open again to the federal government to do whatever it needs to do to support its, whatever you want to call it, what it does.
Well,
okay.
What it's supposed to do, and what the federal government is supposed to do, is defend our borders, establish roads, and facilitate, not destroy.
And third, the revenue source food of the federal dragon will instantly dry up. Well, it's obvious, and it's reasonable to think that if you stop feeding the beast, it starts decreasing in size. It starts, in this respect, the federal government will start decreasing, will be contained within its little 10 square mile area if all the states follow this writ and close the doors to the recorders. Now, the sheriff's participation in this is to see that the duties of the recorders are followed, that no lien shall be filed. And that's why both the recorder of the counties and the sheriffs will be respondents in the petition. They have to respond to it. But the first thing we're going to do before we file the petitions are to go to each of the sheriffs, not each of them, but go to the sheriff's office and recorder's office and ask them to stipulate to this writ. So far, we've had sheriffs already willing to stipulate, and we've heard.
Okay, I haven't been able to see anything, so I can't see it.
So we will be compelling. We will be asking for stipulations from both sheriffs and recorders of every county that we can get to in accordance with the people that will help us, and that's, we hope, are the listeners here and others. To ask them to stipulate to this writ, so when we do file in the Supreme Court, there will be no adversarial positioning there. And the Supreme Court would have to grant it and close those doors. But let's say that the Supreme Court denies it. The sheriff himself has the right to compel the recorder to not accept instruments under the law. And basically, the sheriff, or a group of sheriffs, can go right to the Supreme Court justices, and because they're violating the law, arrest them on charges of violating the laws. Will they do it? I know some pretty gutsy sheriffs that may just do that. Okay. Then what happens? This will force an end to debt-based currency owned by the foreign corporations known as the Federal Reserve and our tributes for privilege of using their lien properties. The only tax that we have to pay, the income tax, is based on the use of these Federal Reserve notes, not on your labor or anything else. When you transact for these, transact with these instruments, the owner of these products wants their due pay for your using them, and that's what the income tax is based on. You'll see it in the book that Robert and I had written. They own it all, including you, and it'll point out specifically what that income tax is based on. And you'll be surprised that when the IRS moves against you, they actually move in admiralty law. The cases that are provided in the book shows you. They move in admiralty law and then make it a civil action, appear to be a civil action right after. So you're in admiralty all the time. And admiralty is contract on the high seas in the time of war. Maritime is contract on the high seas in the time of peace. Second, this is the most fundamental step we can take towards restoring our freedoms. And as Gary said earlier, this step doesn't involve bloodshed. I don't think any one of us wants to see the country collapse in a revolution. But this is a paper form of attack that should compel every state to close their recorder's office to the federal government. 3, as you learned in previous webinars, if you use their property, you are subject to the terms and conditions. Furthermore, you actually own nothing as the debt currency carries hidden liens. Okay, the Federal Reserve note that we use every day is only backed by one thing. It's called the confidence of the American people. Now, confidence is not a unit of money. It is an emotion. So it's an emotion backing our currency. And as in the book, we do show and prove that the dollar itself, the Federal Reserve note itself, has a hidden lien that carries over to the very thing you purchase. So if you take $10 to buy a table of a Federal Reserve note, unredeemable note, the lien of $10 goes on the table you bought, so you don't own it. It's already lien. But let's say an example of a gold coin. You paid a $10 gold coin for that table. All the qualities in that gold coin also transfers over into the table. And you have absolute rights, titles, and interests in that gold coin. So transferred over to the table is absolute rights, titles, and interests in that table. Okay, there is little chance to tackle the currency monster in their courts. We're talking about the federal courts. However, by making it an issue for the states to follow the supreme law as defined and laid out by the Supreme Court of the United States, we can keep it entirely as a state issue. Success in just one state entitles each and every state the same remedy. We only need one. It's true. If one state declares that it's unconstitutional, now we're not asking for the state to declare it unconstitutional, but if one state recognizes that the law interpreted by the Supreme Court is the law of the land right now, and says to the recorder's office and the sheriff, this has to be compelled upon you, every state will follow suit. Every county, if there's only one sheriff and one recorder in one county, every county in that state would have to follow that suit. So we've closed basically every recorder's office to the Federal Reserve, or to the federal government at that point. So now let's discuss how this will be accomplished in the highest state courts. Then what, well, we already had that, okay. Nature of the case. Since 1968, the non-redeemable Federal Reserve notes do not comply as payments under the 16th Amendment, and that's your income tax amendment of the Federal Constitution. In the 1870s, the Supreme Court of the United States had defined the nature of legal tender in legal tender cases. There are several cases that were heard through the Supreme Court from 1868 forward to about 1879. And these all dealt with what is the true nature of the legal tender that we use, that they used at the time. In accordance with the decision, legal tender must be issued by the United States and redeemable in gold or silver coin. The determinations of the Supreme Court of the United States do not recognize non-redeemable notes as payments, but only those notes that may be redeemed at a future date. So it's important to know that at that time, that the defining of what legal tender is in accordance with what the United States has to follow, the Supreme Court says it has to have two qualities. It has to be issued by the United States, and it also has to be redeemed at one point or another in the future by species, and species is gold or silver coin. You have any notes on that, Robert?
Well, the only note I have is we show in our seminar that the Federal Reserve System, and I think all the listeners know this, is not an agency of the United States. It is actually a foreign-owned corporation, and that comes right out of a Ninth Circuit case right here in California, that it is not part of the federal government. So that, therefore, the Federal Reserve note fails as the Supreme Court defined what legal tender is on two key accounts. One, it's not issued by the government of the United States, because right in Title 12, Section 411, that's current law today, they're issued by the Federal Reserve banks, not by the federal government. And two, they're not redeemable, ever. So they fail according to case after case after case of the Supreme Court of the United States. Go ahead, Ron.
Okay. What's the difference between legal tender and lawful tender? Legal tender is paper money. Sometimes it could be coin. If the coins are scraped and less in value or debased, they then become legal tender, but not lawful tender, and I'll explain that in a moment. When it is convertible to gold or silver coin, it is known as redeemable. When nothing backs the paper money, it is known as non-redeemable or non-funded notes. Okay, what's lawful tender? Lawful tender is gold or silver coin struck by the mint, branded by the United States, weighed by the United States, and standardized throughout the realm of the United States. This tender is known as species. Pre-1933 gold coins are lawful tender, and pre-1965 coin silver are a lawful tender. In 1933 and 1965, gold and silver respectively ceased to be minted in conformity with the law. Okay, so that's the point at which the currency failed to be legitimate, failed to be lawful under the interpretation of the Supreme Court of the United States, that last date of 1965. And that's what we have today is the Federal Reserve notes that are not backed by anything but confidence. Fluctuation and debasement. Fluctuation is when we have deflation and inflation. And debasement is when you actually reduce the value of something. Lawful tender seldom, if ever, fluctuates in value. That's your gold and silver coins. They seldom ever fluctuate in value. Nor is lawful tender debased, which is when the quantities of grains of gold or other metals are decreased within the coin. Legal tender that is redeemable fluctuates in value consistently. In the states under the Articles of Confederation, when states produced legal tenders backed by bullion, the state had to double the security of the face value of the legal tender, also known as a note. The reason that the state had to double the security, let's say it was a $10 note they put out there, they had to have had $20 of gold or silver in the vaults to cover it, because the currency, the paper money, depreciated. And sometimes it depreciated so much they'd have to have that extra money to pay off the notes. And money means gold or silver, not paper currency. This is because paper money has always fluctuated in value, even if printed as redeemable. Fluctuation and debasement continue. Legal tender that is non-redeemable fluctuates in value. $1 today may buy you 10 apples. However, tomorrow the same dollar may only buy you 2 apples. And we know that. We lived through that. In this strategy of non-redeemable notes that fluctuate, at any given time, some of the people will lose their wealth, and others will gain wealth. But in the end, all shall have lost their wealth. Look at the QE342 infinity. Every time they put out extra paper money, our money fluctuates. The dollar is not as valuable today as it will be tomorrow if they put out more. The dollar is more valuable today than it will be tomorrow if they influx more paper currency into the system. You're starting to be taxed without your knowledge, because every time they burden the society with more paper money, it pulls the value from the dollar, and they get that. A little history, and this comes from Senator Carter Glass, formerly the Secretary of the Treasury in 1932. The Federal Reserve System has been threatened with raids upon its gold supply by foreign nations, notably by France. There has been the threatening situation, that conjecture, and it is a conjecture being that the country wanted to affect our situation with respect to reparations and with respect to indebtedness to the United States. I do not make this assertion. I say it's conjecture. The officials of the Bank of France have simply outwitted the officials of the Federal Reserve System of this country. So back from 1930 to 1932, we were in the Great Depression. It went past that date. However, during that process, the United States did something that was incredible and treasonable to the American people.
Show them on the next slide.
Okay. Slides up here.
Yeah, you went one too far.
Okay, there we go. This is the right one, right, Robert? Let's see.
No, go back one.
Okay.
Yep.
Okay, in 1932, European countries were suffering under the Great Depression. Great Britain was on the cusp of losing its pound sterling. In order to prevent the United States, the United States had lent gold certificates with a moratorium of 1 year before payments had to be made. In fact, several debtor nations, and they were debtor nations over in Europe, inclusive of France, came to the United States to borrow these certificates that were redeemable in gold. Each nation had the same terms, a 1-year moratorium. That meant that they didn't have to pay it back for 1 year. Then they would make payments. No sooner was this transaction perfected as when the nation of France sent barges to the East Coast to redeem these notes into gold. That meant France for 6 weeks had continuously sent barges, cashed these gold certificates in at the banks in New York, and took the gold back to France. These were raids on the actual gold by several of these debtor nations, but France removed the greatest amount. In 6 weeks, we lost 750 million of actual gold coin and bullion. That was basically 1/6 of the entire stock of monetary gold in this
Now
country.
let's put that in perspective. That's $750 million in 1932 money. Divide that by 20, and you get the number of ounces of gold that was taken by France. That would be 37.5 million ounces of gold was removed by France.
Now understand, France did not need the money. It had plenty of gold, but it just did not inform the United States it had it. Okay, that was 1/6 of the entire stock of money. Okay, in less than a year, at the rate we should be bare of it, they're saying if we don't stop this now, we're going to lose every ounce of gold that we have. But they didn't stop it. Europe wanted the gold for its own sake, wanted it while she could get it. So there was no rhyme, no reason to that. They just wanted the gold. They greedy, I guess. But more was involved. These debtor nations owed the United States at the time more than $10 billion in the form of public debt, war debt. So they were already in debt to the United States, $10 billion worth of debt. Yet many of the nations had accounts in the U.S. What happened next is that these nations were cashing in on the U.S. accounts and taking gold coin and bullion from the U.S. banks. So they were closing their accounts. All the European debtor nations came over here, closed their accounts by taking the gold out of the country again. These raids eventually compelled the U.S. off the gold standard. So was it strategized? I think so. But what we get into next is strictly why I call the act treasonous, that the United States had loaned money in the first place. Congress has enumerated powers, and in those enumerated powers it says everything they can do. They can't go outside of these. They're limited in scope. Okay, the first one is to establish a post office and post roads. Second, to promote the progress of science. We seem to have the wrong one in here, Robert.
Well, no, actually,
Okay.
to constitute tribunals, that means the lower courts.
Yeah,
to
but we
punish.
have, yeah. Well, they had the right to borrow money, and that should have been the third one in this, and I don't see it in this one.
Maybe it's
but-
on the next one.
Let's see here. Nope, it isn't. But in the enumerated powers,
There you
Congress,
go, Ron.
okay, there it is. Okay, well that one shouldn't have been in there. Okay, to borrow money is what's granted to the United States, and there's a reason why it was granted the ability to borrow money. Money again was specie, gold and silver at the time. If the United States went to borrow money, there would be a limit from anyone who would lend the money to the United States. Just as if your neighbor came to you and wanted to borrow money and you were gracious enough to give it to him, you're not going to give him all your money. You're going to give him some of the money and be reasonable at it. So let's see if that power, if you
Well,
look at these,
Ron, let me expand on that a little bit.
okay,
Please note that it says to borrow money. It doesn't say to loan money.
that's
It
what we're
says,
getting into, Robert.
okay, to borrow
next
money. And what was
Yeah.
money then? Money was gold and silver. It was not credit debt instruments.
Okay, so loaning money, and as Robert stated, in the enumerated powers, there is no power granted to the United States to loan money, and for obvious reasons. First of all, let's say it had the power to loan money. It could loan $1 to another nation out of the purse of the American people. But if there's no caveats on that loaning of money, it could take the entire purse and loan it to the foreign debtor nations, and there would be nothing the United States people could say, and if it had done that, it would spiral the United States into a bankruptcy, into a debtor system. But that's exactly what they did in 1932. They lent the purse of the people of the United States and put us basically on the rim of going into bankruptcy. Basically, we were in bankruptcy. So they did something that was treasonous. They never had the power to loan money in the first place, as you can check the enumerated powers, but they did do that, and they collapsed the system on a gold standard. So at the time of this, off the gold standard, but I do not believe there would be one person that knew the history in this area of money would doubt that the government was disloyal to every American citizen. In fact, in accordance with the maxim, one cannot serve two masters, for he shall benefit the one and prejudice the other. If you look at it in that direction, the United States was treating the debtor nations as though they were the masters over the United States, and treating the people of the United States as though they were the debtors or the servants to the master. The American people were prejudiced by its creature, the U.S. government. Moreover, foreign debtor nations were benefited. That is not only disloyal, it is treasonous. So what did the United States have to do next? It wanted a scapegoat. And what it did was, in 1933, the President of the United States, Delano Roosevelt, put an act out stating that every American was a hoarder. Every one of us was a hoarder, and it was a crime to be a hoarder. The United States, they said, had entered the path of inflation. That's what going off the gold standard did. Our money now would fluctuate. This was the beginning of the end of the gold dollar. Well, the people now believe it. The franc was good gold money of the world. So where the United States currency was good gold money of the world, now France was the good gold money of the world. And
but let's, Ron, let me elaborate on the hoarding a little bit.
Well, I'm not done with it, Robert.
Okay, thanks.
Yeah. Okay, so following the collapse of gold, and this is where we were accused of being hoarders. Let's go to the next one here.
Oh, they need to know what hoarding is. What is what is a hoarder, Ron?
You can explain it.
Okay.
Okay.
If you were alive in 1933 and you had money, meaning gold, and you had gold in excess of $100, you were declared to be a criminal for holding on to your property, for having over $100 either in your account, your safe box, or your pocket. That was declared outright to be a crime because you were hoarding it. You were holding on to your property and not giving it away. And for that, you were accused and you were automatically declared by the president to be a felony criminal, punishable by up to 10 years in prison and $10,000 in fines.
So even at that time, the United States government went through the safe deposit box when the banks were closed. And for all the gold coins and gold certificates, they replaced them with silver certificates.
Actually, not silver certificates, silver Federal Reserve notes.
Yeah, silver Federal Reserve notes. Okay. All right. Let's see. The American people became the scapegoat, as we see. And most of us weren't alive. I don't think most of us were alive. Maybe we were, maybe some of us. But what that achieved is it was the first point at which the federal government reneged on a promise to pay. Now understand that these gold certificates were promises to pay. And we trusted our government to hold our gold, our property, at that point. But when they turned around and created an act accusing every American of a criminal, they took our property that we owned. And you'll notice that in your own state constitutions, there is never a grant to the state constitution for them to take money or even address the money of the people. That preceded both the Articles of Confederation and the Constitution. We own the money before these instruments were ever created. Therefore, it was ours, and not one constitution within the state has ever granted from the people to the state the ability to take our money. However, the United States took this power, and there's no traceable authority for it to exist. Now, we may think that it had something to do with a time of emergency, but we'll get into that in a moment. Let's see. So we talked about the reneging of the promise to pay. Okay, let's go to, okay, let's say it's a state emergency. I mean, what are the powers? Does Congress increase the powers during a state of emergency? One would think they would have that ability, but do they? The only crimes specifically addressed in the federal Constitution are piracy, counterfeiting, and treason. No other crimes are addressed. However, if someone were to rob a post office, that would be an implied power and certainly would be a crime. But the United States would first have to have subject matter jurisdiction over the matter, such as post office. It has to have that in its jurisdiction, and it does, and everything that pertains to it, to the post office. Nowhere in the Constitution is mentioned the crime of hoarding. In fact, the people were addressed as sovereigns without subjects. That was a case from Chisholm versus Georgia. And they were also addressed as the majesty of the people.
Ron, it is mentioned in the Constitution, in the Fifth Amendment, the government may not take your property without
absolutely.
due process. So right there, it's in the Constitution. It requires due process to take your property. And here, Franklin Delano Roosevelt, by executive fiat order, declared you to be a criminal and stole your property at gunpoint.
Okay, so if you think that the United States had the powers to increase its power, you'd be sadly mistaken, because even under a state of emergency, it did not have that power to create a new crime. While emergency, and this is a case Wilson versus New, and it says, while emergency does not create power, emergency may furnish the occasion for the exercise of power. Although an emergency may not call into life a power which has never lived, to declare the people hoarders, that's a power that never lived. Nevertheless, emergency may afford a reason for the exertion of a living power already enjoyed. So any power that's already in the Constitution, they can raise, they can put out there and use. But a power that isn't in the Constitution, in accordance with Wilson versus New, they cannot create. They cannot create a new power. The constitutional question presented in the light of an emergency is whether the power possessed embraces the particular exercise of it in response to a particular condition. So what they're saying there is that, let's say they have the war powers in the Constitution, so we have to look at the particular conditions under which they may raise that, and that's that point there. Thus, let's see here. Okay, thus the war powers of the federal government is not created by emergency of war, but it is a power given to meet that emergency. It is a power to wage war successfully, and thus it permits the harnessing of the entire energies of the people in a supreme cooperative effort to preserve the nation. But even the war powers does not remove constitutional limitations safeguarding essential liberty. What are essential liberties? They're called substantive liberties. They are the liberties that came before the Articles of Confederation and the Constitution. They were intact. They dealt with money, survival. They dealt with the right to build a home, to provide for your family. All
to also be a physician.
Yes, to also be a physician. I wish my end button would work, Robert.
Well, actually, Rob, the reason why it doesn't is because you're not on the slideshow itself.
Is there one in back of this?
No, you have to click on the bottom of your screen and show the whole slideshow itself for your end button to work. And I can't do it for you.
I don't see any.
On the bottom right, Ron, you're close to it. You're
right
close.
Here? Right there?
No, I can't see it. I'll do it for you if
Come on, Ron, you're very close. Ron, no, go over one more to the right. One more to the right.
One more. That's it. Hit that. Now your end button will work.
Terrific.
Now you can point.
Okay. The federal government is not created by the emergency of war, but okay. So essentially, even during a time of war, the federal government does not have a right to touch upon your substantive liberties. Those were to be protected by government, not to be restrained by government. Collapse of the silver standard. The last silver certificate redeemed was in 1968 or 1965, whichever. Two points on that one. The silver minted coins ceased after 1964. After 1968, one could not bring a silver certificate into the mint and have it redeemed for a weight of silver. This was the second time the United States reneged on its promise to pay to the bearer on demand. So we see a pattern of the United States not performing under its promise to the American people. 2 times it has failed the American people, and it's basically stolen their wealth. The word of the United States is worthless. The wealth of the American people now ceased, because as of that date, the Federal Reserve notes became unredeemable. They had nothing backing them. So therefore, if you use an instrument that has no value backing it, no commodity backing it, and purchase something with it, you do not own it. The person who owns the notes owns that product or that service that you paid for.
Now it goes, this is interesting because at the meeting, I presented in my presentation on money a $20 gold certificate. And it says up at the top, this certifies that there is on deposit in the Treasury of the United States of America $20, which is 1 ounce, in gold coin payable to the bearer on demand. Now that note, that certificate is in my hand. So whose coin is it that the government is holding? It's like a baggage check, that certificate. The baggage doesn't belong to the SkyCap, it belongs to you, and you have proof of that because you have a ticket. That was my ticket to the gold. The government isn't giving it back to me, so what did it do? It stole my gold. That's a felony.
Yeah, and one of the things about currency or actual money, it represents all the labor you have placed into earning it. A $20 gold coin was $20 worth of labor. No matter how you gained it, it was $20 worth of your labor. So at that point, they were stealing your energies. They were taking everything that you worked hard for and moving it away from you and into their treasuries. Paper currency has never been intended to circulate in the United States. Such a medium, that's paper money, has been always liable to considerable fluctuation. Its value is continually changing, and these changes, often great and sudden, expose individuals to immense loss, are the sources of ruinous speculation, and destroy all confidence between man and man. To cut up this mischief by the roots, a mischief which was felt through the United States and which deeply affected the interests and prosperity of all, the people declared in their Constitution that no state should emit bills of credit. If prohibition means anything, if the words are not empty sounds, it must comprehend the emission of any paper medium by state government for the purpose of common circulation. There's more to this. During when the states were newly formed under the Articles of Confederation, they already had used legal tender paper money. And what happened is because it depreciated so much, they said this is a terrible thing. It actually stole wealth from people. It caused friction among the people and between government and people. So the emitting of bills of credit was actually placed in the Articles of Confederation. That meant they could emit these paper currencies. But when it came to the federal Constitution, they said, no way will we ever grant to our government this power to emit bills of credit.
Go to the next slide, Ron. Hit N.
Yeah. The power to coin money is one of the ordinary prerogative of sovereignty and is almost universally exercised in order to preserve a proper circulation of good coin of a known value. Good coin is an honest coin in the home market. In order to secure it from debasement, it is necessary that it should be exclusively under the control and regulation of the government. For if every individual were permitted to make and circulate what coin he should please, there would be an opening to the grossest frauds and impositions upon the public by the use of base and false coin. And the same remark applies with equal force to foreign coin. If allowed to circulate freely in a country without any control by the government. Every civilized government, therefore, with a view to prevent such abuses, to facilitate exchanges, and thereby to encourage all sorts of industry and commerce, as well as to guard itself against the embarrassment of an undue scarcity of currency, injurious to its own interests and credits, has found it necessary to coin money and affix to it a public stamp and value, and to regulate the introduction and use of foreign coins. So basically, what the newly formed states were saying is that this needs to be in the national government's hands. They need to regulate the value of the coins. They need to coin the money and keep it standard throughout the entire states at that time. At that time, we were also using foreign coins in the newly formed states, but it was controlled and restrained by foreign nations. So they actually had control of the states at that point that were using the money. This is why the states themselves started printing their own paper and coining their own precious metals. But the problem is when you have different states coining their own metals, they're not of a standard weight. They're different. So a dollar in, let's say, Massachusetts would not be the same weight as a dollar in Pennsylvania. So it was causing friction that way, and this is why the federal government was giving that right to coin money and keep standard the weights and measures of it. The grounds upon which the general power to coin money and regulate the value of foreign and domestic coins is granted to the national government cannot require much illustration in order to vindicate it. The object of the power is to produce uniformity of value throughout the Union and thus to preclude us from the embarrassment of a perpetually fluctuating and variable currency. So that's what we have today, don't we? We have a fluctuating and variable currency. Again, that example about apples, today we may be able to buy 10, tomorrow 2 with the same dollar bill that we have. Okay, this comes from Jonathan Elliott's Debates on the Adoption of the Federal Constitution. By our original Articles of Confederation, the Congress did have power to borrow money and emit bills of credit on the credit of the United States, agreeable to which was the report on this system as made by the Committee of Detail. When we came to this part of the report, a motion was made to strike out the words to emit bills of credit. Against the motion, we urged that it would be improper to deprive the Congress that power, that it would be a novelty unprecedented to establish a government which should not have such an authority, that it was impossible to look forward into futurity so far as to decide the events might not happen that should render the exercise of such a power absolutely necessary, and that we doubted whether, if a war should take place, it would be possible for this country to defend itself without having recourse to paper credit, in which case there would be a necessity of becoming a prey to our enemies or violating the Constitution of our government. So some of the people thought that we needed to grant to the newly formed Constitution that power to emit bills of credit. But this is what they say. And that considering the administration of government would be principally in the hands of the wealthy, and that's what they're saying, is that the government might end up being in just the wealthy people's hands, and which it is, there could be little reason to fear an abuse of the power by an unnecessary or injurious exercise of it. But, sir, a majority of the convention, being wise beyond every event and being willing to risk any political evil rather than admit the idea of a paper remission in any possible case, refused to trust this authority to a government to which they were lavishing the most unlimited power of taxation, and to the mercy of which they were willing blindly to trust the liberty and property of the citizens of every state in the Union, and they erased that clause from the system. There was a 11 to eliminate that clause out of the newly formed Constitution. to two that wanted it in there. So the United States was never granted the power to issue paper money as legal tender. It's right there, right in the notes of the convention. And that's why you'll see emit bills of credit in the Articles of Confederation, but you will not see that same power within the Constitution, the federal Constitution today. Robert,
I want to make a little comment on that. There was a heated debate at the Constitutional Convention. You can get Madison's notes. You can go online. I think the Avalon Project can get you Madison's notes, and you can read this, where they stood up one by one. Only two people were in favor of emitting bills of credit. The rest were negative. And I'm from the state of Delaware, and my home constitutional representative, George Reed, arose, and I'm not a Bible thumper, you all know that, and he said, this man said back then, 250 years ago, said that emitting bills of credit, in his opinion, was the same thing as the mark of the beast in Revelations.
Okay, what law is not being followed by the sheriff and recorder? The Supreme Court of the United States has repeatedly defined legal tender as paper currency that is redeemable in species. Species is the lawful money of the United States and is coined in gold and silver. I think everyone may have seen a silver coin, if not seen a gold coin also. Species is known as lawful tender. Lawful is that which has both form and substance. The shape of the coin, that it's round, it has depth, and that it has, that's the form of it, and the substance is gold. So the coins have a circular shape, a diameter, height, and thickness, and the substance is gold. Okay, fixed. Okay, and then it has a fixed weight on it. Okay, now I'm locked up, Robert.
You're locked up?
Yes, I am. Let's see here.
Did you hit in? Oh, you
Yeah.
got it. Go back.
Yeah, I have to do it by hand, I think. Let's see. Okay, here we go. Okay, that's good.
Hit in. There you go.
Okay. Can the 16th Amendment add new interpretations? Assuming that we have correctly interpreted the meaning of the term by law made current, this is a case in the Act of 1806, what would be the status of this phrase if the Act had not been amended in 1951? Would we then say we must now give the provision of law a new interpretation and make it apply to coins made current in foreign countries? Otherwise, it would become inoperative and have no further place in law. So what they're saying here is that the Act of 1806 dealt with foreign coins, and they had to amend that Act in order to provide for a new interpretation. So it says, a law and its application can only be changed by Congress either by abolition of the old law and the passage of a new law, or by an amendment of the old law, clearly showing that Congress intended for the law to have a new meaning. We cannot wish a new interpretation into a law or give it a new application merely because the situation which caused its passage has ceased to exist. So when you think about the 16th Amendment, the 16th Amendment, Income Tax Amendment, was passed in 1913 when the tax was collected through species or its equivalent. That meant gold certificates, silver certificates, or the gold and silver coin.
And by the way, look at this case below. It says it's the 10th Circuit, so it's a high court, and this is a modern case, 1960. And what they're saying is you have to apply the statute or a provision in the Constitution to the meaning of the words at the time it was passed, or you have to abolish the law and reinvent it totally. Read here Peabody versus Eisner, which is a killer case on the issue of the income tax. Go ahead, Ron.
Yeah. In Peabody versus Eisner, decided on the same day and deemed to have been controlled by the preceding case, the court ruled that a dividend paid in stock of another corporation, although representing earnings that had accrued before ratification of the amendment, was also taxable to the shareholder as income. The dividend was likened to a distribution in species. Again, species is your gold and silver coin. This case arose under the Federal Income Tax Act of October 3rd, 1913. So here we have what the issue is about. It's about a dividend that has to be paid for by the defendant under the Income Tax Act. The controversy is over the first cause of action set up by plaintiff in error in a suit against the collector for the recovery of an additional tax exacted in respect of a certain dividend received by plaintiff in 1914. So the Internal Revenue wants to take a tax on the dividend that the plaintiff received. It hardly is necessary to say that this case is not ruled by our decision in Town versus Eisner. Since the dividend of Baltimore and Ohio share was not a stock dividend but a distribution in species of a portion of the assets of the Union Pacific and is to be governed by all present purposes by the same rule applicable to the distribution of a like value in money. It is controlled by Lynch versus Hornby. As is evident in Peabody's case, the Supreme Court deemed the measure of income for the tax as species or instruments that were convertible to species. Well, what we mean by that is that 1914 is 1 year after the Income Tax Act was passed. Peabody actually specifies what the payment is to be under that income tax, and it says species, gold or silver or its equivalent. Whether
Ron, not just payment. It says here, right in front of you, it says by the same rule applicable to the distribution. That means your earnings of a like value in money.
Correct.
So the measure of the income tax, the Supreme Court is telling us in 1914 that the measure of the tax from the 16th Amendment is specie or its equivalent, and equivalent at the time, which you'll see in the legal tender cases, the equivalent is redeemable notes.
Yeah. So it's actually defining what type of payment falls under that taxing clause. And it is saying the redeemable notes and species. The current Federal Reserve notes are not convertible to species. In fact, they have no convertibility into any value or unit of wealth. That's what we have in our pockets today. And this is Juilliard versus Bremen, an 1884 case.
This is the seminal case. Please pay attention to this because this summarized all of the legal tender cases from the Civil War to this time, and everything rests on what this case says. This is Supreme Court talking to you.
Yeah, and even currently it rests on that.
Yes.
All cases today rest on this case. The manifest intention of this act is that the notes which it directs, after have been redeemed, to be reissued and kept in circulation, shall retain their original quality of being a legal tender.
Ron, let me elaborate on this.
Okay.
So they understand. What happened was, during the war, Congress issued greenbacks that said redeemable, but they weren't redeemable at the time and people didn't want them. So there was rampant inflation with the notes, but by 1879, the Congress started redeeming the notes. In other words, you could bring in your greenback and you would get paid in silver or gold, dollar for dollar, the paper, and you would receive a coin. Then what Congress decided to do was pass an act so that those paper currencies could be kept in circulation and reissued after they were redeemed. So you could take your $5 note into the Congress or into the Treasury, get $5 in coin, they would then reissue that note into circulation, which was redeemable. So that's what they're discussing here,
right. Whether
doing that and reissuing those notes is constitutional.
Yeah. Now this was in a time of war also, and that's why the question arose basically, because these notes were reissued and they were questioning whether they would ever be redeemed, but this here will address that. The single question, therefore, to be considered, and upon the answer to which the judgment to be rendered between these parties depends, is whether notes of the United States issued in a time of war under acts of Congress declaring them to be legal tender and payment of private debts, and afterwards in a time of peace redeemed and paid in gold coin at the Treasury and then reissued under the Act of 1878, can, under the Constitution of the United States, be a legal tender in payment of such debts. So we have these notes being reissued again, and they're questioning, can they be tendered as a payment in such debts or taxes and things of that nature. Upon full consideration of the case, the court is unanimously of opinion that it cannot be distinguished in principle from the cases heretofore determined, reported under the names of legal tender cases. Who adheres to the views expressed in his dissenting? Okay, we're talking about the judge. Let's go to the next here. Legal tender cases. This is what they're referring to in the Juilliard case. The Legal Tender Acts do not attempt to make paper a standard of value. Okay? So that's one of the points that the United States never raises when they're defending their authority to issue legal tender money, paper money, without any commodity backing them. They're saying in this case that paper money was never intended to be a standard of value. We do not rest their validity upon the assertion that their emission is coinage or any regulation of value of money, nor do we assert that Congress may make anything which has no value money. Oh, wait a minute here. They're saying that they're not asserting that Congress can actually make a paper money not backed by anything, because that would be a shell game, right? Give me your property, I'll give you a piece of paper sort of situation. What we do assert is that Congress has the power to enact that the government's promises to pay money shall be for the time being equivalent in value to representative of value determined by the Coinage Acts, or to multiples thereof. It is hardly correct to speak of a standard of value. The Constitution does not speak of it. It contemplates a standard for which it has gravity or extension, but value is an ideal thing. The Coinage Acts fix its unit as $1, but the gold and silver thing we call $1 is, in no sense, a standard of $1. It is a representative of it. There might never have been a piece of money of the denomination of $1. There never was a pound sterling coined until 1815. We accept a few coins struck. If we accept a few coins struck in the reign of Henry VIII, almost immediately debased, that means some of the volume of gold and precious metals were taken off the coin, yet it has been the unit of British currency for many generations. It is then a mistake to regard the Legal Tender Acts as fixing a standard of value or regulating money values, or making that money which has no intrinsic values. So they're saying in these cases that the federal government now depends on and uses in its arguments, they're saying right in this case that they would never grant the power to make money that has no intrinsic value. But that's, unless you consider confidence an intrinsic value.
In other words, what they're saying in this case is that Congress doesn't have the power to make something into money which has no intrinsic value. And at that time, intrinsic value was a fixed weight of gold or silver.
Clearly evident in the legal tender cases, even in time of war or emergency, the legal tender ultimate goal is redemption in species. Okay, look at your paper money today. There's no promise to pay. There's nothing on them that says that they have a commodity backing them up. It just says a blank $10 or $20. Okay. No one supposes that these government certificates are never to be paid, that the day of specie payment is never to return, and it matters not in what form they are issued. The principle is still the same. Instead of certificates, they may be treasury notes or paper of any other form, and their payment may not be directly in coin, but they may be first converted into government bonds or other government securities. Through whatever changes they pass, their ultimate destiny is to be paid. Get the point? The government rests on these cases for their authority to put out non-redeemable paper money today.
Actually, the government rests on these cases for its ability to put out legal tender.
Non-redeemable.
Legal tender. However,
non-redeemable.
Hang on, Ron. Hang on. They rest on these cases to put out paper legal tender. However, what the government is not telling you is that the cases they're resting on require that the paper be redeemable. That's what they're not telling you. So the mandate that you are compelled to use non-redeemable paper does not conform to any of these cases that the government is relying on for their alleged power to issue paper.
And that's particularly the issue, is that these current Federal Reserve notes have no commodity, but yet they're relying on these cases that say that the only way the government may have legal tenders floating around is that they must have on them at a future time will be paid to the bearer a amount of gold or silver as what the face value of the currency says. So that's really the issue of our writ. And since
Next slide, Ron. Next slide.
Title 31. Okay, I just want to say that is actually the issue of the writ, is that we have 2 points here. We have the legal tender cases that have to be redeemed, and then we have, since 1968, non-redeemable notes. It doesn't fit. It's unlawful. It's not in agreement with Supreme Court interpretation. Okay, the next is Title 31, Chapter 51, Section 5103. This is how a legal tender is defined today. United States coins and currency, including Federal Reserve notes and circulating notes of the Federal Reserve banks and national banks, are legal tender for all debts, public, private, public charges, taxes, and dues. Foreign gold or silver coins are not legal tender for debts. Above evidence how the current legal tender is defined by its use for all debts, public charges, and taxes and dues. But note the second sentence. Foreign gold or silver coins are not legal tender for debts. The law prescribes that this code must be interpreted concerning the whole body of the code and not by segmented portions for interpretations. And that's a rule that is well known in the legal field, is that you have to look at the entire law, not just a portion of it, for its interpretation. These foreign coins would have once been comparable to United States coins species, your gold and silver coins, the composite of which were gold and silver. No one would argue that this section 5103 is the current law of the United States, because it is. It is current law. However, it is obvious that this code is not addressing clad coins in the first sentence, simply for the reason the whole of this code section implies a comparison between U.S. and foreign gold and silver coins. You see that where it says United States coins and currency and foreign gold and silver coins? Are they saying United States clad coins and currency and foreign gold and silver coins? It doesn't jive. They would have to be referring to gold and silver coins up here. But we'll go down to further proof. Okay. It is self-evident that there are no foreign gold and silver coins circulating as currency within the United States. That's not only because the law forbids using them as legal tender, but also because foreign gold and silver coins are not minted as currency, not lawful currency. Another interesting point in the above code is that the United States has not mentioned any foreign paper money. Paper money and clad-based metal coins are the only currency within the economic international borders of most, if not all, countries worldwide. Concerning the constitutionality of this section, because when you look up a code, if you look up on Westlaw or one of the law sites, it'll give you the case laws that support these codes. And this is how they supported this constitutionality of Section 5103, the defining of legal tender. Concerning the constitutionality of this section, the government points to and relies on the support of former Section 452, Title 31, was constitutional. Now look at the date of it, 1872. Well, in 1872, they had money, legal tender, backed by a commodity of gold or silver. So I would say that was constitutional. But it's not bearing on the current legal tender that has nothing backing it. The constitutionality of the acts of Congress of February 25, 1862, of subsequent acts in addition thereto making certain notes of the United States a legal tender and payment of debts reaffirmed. So they're relying on these older cases for the constitutionality of the current Federal Reserve note, which is not redeemable. Okay. This is a case, Johnson sued Norwich and Worcester Railroad Company on a certain coupon for interest attached to bonds made by said company AD 1860. When the coupons fell due, the amount was tendered in legal tender notes of the United States, issued under the Acts of Congress of February 25, 1862, and several acts in addition thereto, and they were refused. The state court rendered judgment that this tender was not good, and the plaintiff should receive the amount with interest in gold and silver coin of the United States. This writ of error was brought to reverse that judgment. So a state actually declared that the legal tenders were not good in this case. And then the former Section 452 was constitutional when applied to contracts made before its passage. Now look what they're referring to. That's the former section of 5103, Section 5103, that's current today. It applied to legal tender cases. Well, we just discussed that. They were backed by a commodity of gold. They were meant to be paid at a future time.
Ron,
Yes.
just to eliminate confusion, because we're throwing around sections of law, don't worry about 452. Don't worry about any of these sections. What we're showing you is all of the constitutionality of the statutes that are current today are referencing the cases in the 60s and 70s dealing with the legal tender cases. They're all referring back there, including to our modern law of what is legal tender in the code today. So they're referring back to the legal tender cases where the cases said money was gold and silver, end of story. Money was gold and silver, but that the Congress had the power to compel you to use redeemable notes in a time of emergency. Remember, the conditions were the notes had to be redeemable and they had to be issued by the United States Treasury itself. That's what we're trying to show you here, and it's current and modern law.
Essentially, the federal government is saying our right to issue non-redeemable notes are predicated upon these older cases from the 1800s. Well, obviously, it doesn't fit. Paramount importance concerning the constitutionality of the current legal tender definition is that these cases were determined by the Supreme Court within the time period of the 1860s to 1879. Two important qualities were determined to exist under the Supreme Court rulings. The legal tender notes were issued by the United States. In addition, there was a promise to pay in specie dollars. Is someone typing on? We're hearing it. Dollars upon the notes, making the notes redeemable in gold or silver at a future date because of the state emergency during the Civil War. In 1879, the gold standard was reestablished at the pre-war price of gold. A person could redeem his greenbacks for gold at the government's guarantee. So you are seeing evidence that all notes, even in the 1800s and beyond, were redeemable in gold. And again, the defense of the United States on their ability and power to issue legal tender notes that are non-redeemable are based solely on these cases. As viewed in the second case above, the constitutionality of 5103 Title 31 rests on legal tender cases. The legal tender cases were a series of United States Supreme Court cases in the latter part of the 19th century that affirmed constitutionality of paper money. In the 1870 case of Hepburn versus Griswold, the court held that the paper money legal tender violated the United States Constitution. The legal tender cases reversed Hepburn, beginning in Knox versus Lee, and Okay, let's go to the next one. In the legal tender cases, the Supreme Court determined that paper money issued in emergency, which was declared legal tender, had to, at some future time, be redeemable during peace. It also determined that the legal tender had to be issued by the United States. The non-redeemable notes, which are currently in circulation in the United States, were not addressed in the legal tender cases. However, the Supreme Court did say, nor do we assert that Congress may make anything which has no value into money. This is precisely what afloats as currency in America. Paper money without value, save an emotional value of confidence. I hope you're getting this point that there's a conflict right here. Had the United States still maintained redeemable notes, they would have been in conformity with the legal tender cases, with the Juilliard case, and we would have no argument. But since they still rely on those cases, and yet the conformity of the current legal tender notes do not apply to the interpretation of the Supreme Court's determination in what legal tender is, they're in violation and nonconformity with the supreme law of the land. Okay, here's the Crummy case. This is a very current case. It's in 2008. Two employees of KISD tax office declined to accept Crummy's $50 United States American Eagle gold coins for any more than the face value of the coins in Federal Reserve notes dollars as tendered in payment of taxes Crummy owed. The core of Crummy's appeal rests on Crummy's argument that legal monetary value of $50 in the United States American Eagle gold coin is different than and worth more than the legal monetary value of $50 in Federal Reserve notes, or as it is sometimes affectionately called, cash. As legal tender, a dollar is a dollar. Fitting, the Supreme Court has explained, a coin dollar is worth no more for the purposes of tender in payment of an ordinary debt than a note dollar. The law has not made the note a standard of value any more than coin. It is true that in the market, as an article of merchandise, one is of greater value than the other, but as money, that is to say, as a medium of exchange, the law knows no difference between them. That's Thompson versus Butler on that part of it. Note the date. Let's go back. They're referring
it's right there. So stay on the same page.
Okay. Okay. Yeah, I'm sorry. Yeah. Note the date.
The date is 1877.
Yeah. Yeah. So Crummy case is saying that there's no difference between a dollar of gold and a dollar of paper money.
In the eyes of the law. In the eyes of the law.
But they're referring back to an 1877 case when the paper money was redeemable. Do you see the flaw in that? It's in nonconformance. The current paper money is in nonconformity with the legal tender cases, including Thompson versus Butler. The result of what has been presented thus far. All the cases have been relied upon by the government of the United States to define legal tender as being issued by the United States and redeemable in species. As we have seen through case law, the interpretation of the 16th Amendment arises upon payment of taxes in species or its equivalent. The defining of legal tender in Section 5103, we just went over that, previously mentioned, relies upon the legal tender cases which state that the notes must be redeemable. When the 16th Amendment was enacted, it was adopted considering only legal tender paper that were redeemable or species as payment of the tax. That's the Peabody case that argued what the payment for the tax was species or its equivalent. To change the nature of the 16th Amendment to include non-redeemable notes, the amendment would first have to be abolished and a new amendment in its place, or the amendment would have to be amended to include non-redeemable notes. The law is clear on this issue. And we presented case law at the start of this to show you that the interpretation of the amendment has to be at the time it was adopted. And at the time the 16th Amendment was adopted, the currency applied was gold and silver, or their equivalent. We are bound to interpret the Constitution in the light of the law as it existed at the time it was adopted. Well, there it is right there. As the amendment was adopted, we had only species, or its equivalent, paying for public debts, taxes, and etc. The Constitution is a written instrument. As such, its meaning does not alter. That which is meant when it was adopted, it means now. Are the courts bound by the interpretations that existed at the time of the Constitution was adopted? As the courts can never be unmindful of the solemn duty imposed on the judicial department when a claim is supported by an act which conflicts with the Constitution, so the court can never be unmindful of its duty to obey laws which are authorized by the instrument. Well, the laws that are authorized by the instrument are the Supreme Court interpretations of the money system at the time it was adjudicated in the legal tender cases, including Juilliard's case. But what if they come and say it's been public policy to have these notes flowing through this? And we hear a lot about public policy. How does that affect these current Federal Reserve notes? And this was a case that was current with Obama, President Obama. President Obama exceeded his constitutional authority by making appointments when the Senate was on a break last year, or a recess. A federal appeals court ruled Friday. This is from a newspaper article. The court's broad ruling would sharply limit the power that presidents throughout history have used to make recess appointments in the face of Senate opposition and inaction. A unanimous three-judge panel of the U.S. Court of Appeals for the District of Columbia Circuit flatly rejected the Obama administration rationale for appointing 3 members of the National Labor Relations Board while the Senate was on a holiday break. I need to go back. The White House criticized the court ruling. The decision is novel and unprecedented, and it contradicts 150 years of practice by the Democratic Republican administration. That's public policy. White House Press Secretary Jay Carney told reporters Friday, "We respectfully but strongly disagree with the ruling." Chief Judge David B. Sentinel sharply criticized the administration's interpretation of when recess appointments may be made. He added, "This cannot be the law." As is evidence in Obama's case, even though the President of the United States have repeatedly for 150 years made appointments in the recess of Senate, it was not law and failed as a power, though it was considered public policy. So that covers the public policy of them using these notes for, what, 40, 50 years? For about 45 years, the non-redeemable Federal Reserve notes have been implemented in the United States. However, these notes are in non-conformance with the Supreme Law interpretation of how legal tender is defined. Even though this has been the public policy, it is not, however, the law. So now we seem to have covered every position that they can throw at us as far as these legal tenders, and that the law is there. And the purpose of this whole writ is to compel the Office of the Recorder and the Department of the Sheriff to follow the law as interpreted by the Supreme Court in the legal tender cases, which is what we don't currently have. The bottom line, in accordance with the interpretation of the Supreme Court of the United States, the legal tender notes must be redeemable at a future date and also be issued by the United States. The government of the United States has relied upon the legal tender cases to support the constitutionality of the current Federal Reserve notes. They use these cases to support the current currency of the United States, the non-redeemable Federal Reserve notes. The current currency is non-compliance with the interpretation of the Supreme Law of the United States. Article 1, Section 8, Clause 3. Okay, this is the biggie, because this is where the United States says it gets its power to print paper money and that, even though we won over that they voted 11 to 2 to make sure that emit bills of credit was never allowed in the federal Constitution. Okay, to coin money, regulate the value thereof and of foreign coins, and fix the standards of weights and measures. That's Article 1, Section 8, Clause 3. That's the enumerated power of Congress. To understand this section and clause of the enumerated powers of Congress, one has to define it in accordance with the whole of the section, all of the parts. If we were only to view the first part, to coin money, regulate the value thereof, it would appear that Congress has the right to increase the value, decrease the value, or even stop the coinage of money of gold and silver. That's what it would apparently mean at that point. Now relate the term regulate to the phrase and a foreign coin. That's in that clause. Whatever the defining of the term regulate means in this part of the clause, it shall also have the same meaning in the first part of the clause. Congress shall have the power to regulate foreign coins. Well, that's an impossibility. Congress can't regulate foreign coins. They're regulated by the foreign country. So the term regulate can't mean that in the first clause that Congress has a right to do anything to the coin, like raise the value of it, lower the value of it, or do anything like that, because if it has that power in the first part of the article, then it has the power to increase the value, decrease the value, and the standard of the foreign coin. It just would not make sense. It would be an impossible defining of the term regulate if we were to define it as the power of Congress to regulate foreign coins by increasing or decreasing the values of foreign coins. In addition, the value of foreign paper money. Only the foreign nation has the power over its coins and not the United States. Yet, in current cases, the first phrase is usually disconnected from the latter, making the defining to appear as a power to decrease or increase or prohibit coin money. The reasonable explanation of the term regulate would indicate that it is meant to be kept standard. And isn't that what the Founding Fathers have stated concerning a stable currency that does not fluctuate? So that term regulate is another term for keep standard. It is not a power to increase, decrease, or prohibit. Any comments, Robert?
I'm in agreement.
Okay.
I think they've got it. We need to move on and get to the writ and then ask her any questions.
Okay. This writ is not a federal issue, but it is a state matter. Any and all citizens of the states have a public interest in assuring that their public officers follow the law. They also have the right to file either a prohibition or mandamus, or both, to enforce the public duty. A writ of prohibition is used to prohibit an act by a public officer that is outside of the duties of the office. A writ of mandamus is a command to public officers to perform a specific duty that is within the powers of his office.
Now, let me elaborate on this a little bit. Your county recorder and your sheriff both have sworn an oath and signed it to support and defend the Constitution of the United States and the Constitution of their states. And the Constitution of the United States is defined and determined by the Supreme Court. So if the Supreme Court has said that legal tender has to be notes issued by the United States and redeemable, and someone comes to the recorder's office and demands that the recorder records something attacking you that's not based on that, they're acting in violation of the supreme law of the land. And this is a writ to prohibit them from acting in violation of the supreme law of the land and to compel them, mandate them to operate within the law of the land.
Yeah. And the maxim is clear on this. It says if the foundation is unlawful, which the Federal Reserve notes currently current in the United States are unlawful or in nonconformity with the interpretation of the supreme law of the land, then nothing can be built atop that can be lawful. That means all liens, all whatever, all federal instruments built on top of these Federal Reserve notes that are in nonconformance with the supreme law cannot be recorded in that recorder's office because they're illegal, basically. But again, that is not our issue. Our issue will always remain to state issues that we need to control and command our public officers to follow the law. What gives us the right to file? Okay, A petitioner is not required to show any legal or special interest in the results when the question raised in the petition is one of public right and the object of the writ is to procure the enforcement of a public duty. So this is all that's required of anyone. If one of our officers of the state is not following the law, we don't have to have any personal benefit from it, like money or anything like that. We have a right to compel that public officer to perform its public duty under the office. It is sufficient that the petitioner is interested as a citizen in having the laws executed and the respondent duties enforced. That's a common cause case. What is an amicus curiae? It is one appearing into the court as a friend of the court. He may then argue the same as a petitioner in the case. There is usually no cost. Well, in order to support the writ of prohibition mandamus into the Supreme Court, people can join in under what's called an amicus curiae. And under that, you can argue that you have a beneficial interest or a public interest in the case, that if the Supreme Court of the state denies the case, they've denied a substantive right to you. Well, what's the substantive right? Well, your currency is fluctuating. You can't control it. One day you may be on top of the world. The next day you've lost your job, you lost your house, you're on welfare. Those are substantive rights that have been attacked purely by use of these non-redeemable notes. The common cause, that's what I read you on the public interest. A common cause is a position of equal standing with a petitioner that filed the writ. One may aggressively argue a public interest, a right, that he shall lose should the writ not be granted. So the common cause allows you have to pay money to join the suit under your common cause, but you can get right in there and argue alongside of the petitioner right at that moment. Under a common cause, one may move to support the petitioner's position. There may be a court cause. Well, there certainly is a court cause, and that's into the Supreme Court of the state. Okay, the writs command the public officers of the state to uphold the law as interpreted by the Supreme Court until such time that the notes become redeemable. The recorder may not record any federal instruments because they are raised upon notes that are non-compliance with the Supreme Law. We are commanding the sheriffs of the counties to oversee the office of the recorder, that the law is followed to the letter in this matter. All right. Okay, what is the petitioner and respondent in this writ? Because we referred to that. The petitioner is the one that files the writ. The respondents are the sheriff and the recorder in this here. They're the public officers that we want to pull into court to make sure that they follow the law. Now, before we file the writs in any state, we will ascertain from the recorder or the sheriff a stipulation. We'll see that if they'll stipulate to the writ before we even file it. And I believe we have, how many do we have already, Robert, that are willing to do that, sheriffs?
We had at least 40 people at our seminar a couple weeks ago, and I'm hoping that they're going to go to their local sheriff and recorder. We don't know for sure, but the more the better. All we need is one sheriff and one recorder in each state to say, you know something, you're right, we stipulate to this. We shouldn't be filing these bogus instruments. And if they do stipulate to it, that makes it a lot easier, because then you don't have anybody against what you're attempting to ask the Supreme Court to do. The federal government has no standing in the case. It's purely a state matter. So it's you are the petitioner, or we are the petitioners, and your sheriff and your recorder are the respondents. And if they agree to it, and we know that there will be sheriffs who are going to agree to this, we absolutely know this. But the more we get, the better, because if this goes, we would really like to see this go viral across the nation. If it doesn't go viral and it's kept hush-hush, you don't know about the degree of corruption even in the state Supreme Court. But if it goes viral and there's hundreds of thousands or perhaps millions of people writing amicus letters which cost nothing to the state Supreme Court, then the state Supreme Court's going to know that the public knows. And as you all know, the American Revolution was fought and won with only 3% of the population supporting the effort.
Yeah. Robert, let me ask you a question. We know the legal tender cases. Do the Supreme Courts of every state have to follow that law?
They do. That's the law of the land.
That's the importantness of this whole writ, is that we box the Supreme Court into between a rock and a hard place. If they don't grant it, they've broken the law. If they grant it, they're in compliance with the law.
And actually, you know, you and I have discussed this. Go to the next slide. It says discussion of ramifications.
Yeah, I'm there.
Okay, we have discussed this. If the Supreme Court say of California were to deny it, we actually could sue them individually for violation of law, could we not?
It would be a misprision of felony, Robert. They have committed felony in a public office. See, they don't have discretion in this. This is called a ministerial duty to follow the law. It's not discretion. It's not something that is a first impression case as far as that, where they don't have a rule to fall under. They certainly have rules to fall under. They're called the legal tender cases.
Right, and we're asking them to enforce the legal tender cases within the state. Now in California, and I'm sure it's the same in other states, California has a code, it's called Government Code 6850. Government Code 6850 defines the money of accounts of California as the dollar, cent, and mill, right out of the Coinage Act, meaning that the money of accounts of this state, and I guarantee you it's in every other state, or most every other state, is specie. But it also provides a provision for this where the state must accept legal tender notes issued by the United States. And what's interesting is in 1952, you can't find this anywhere, but Ron was able to find it. A law was passed in California mandating that Federal Reserve notes should be redeemable or received at par, along with specie. What does at par mean? That means equal. A $10 note would be acceptable by the state as the same as $10 in coin. However, even in 1952, the notes were still redeemable. They're not redeemable now. And what we're trying to do, here are the ramifications. If the state Supreme Court compels the county recorder and the sheriff to enforce the law as determined by the Supreme Court, the door to attack you by the federal government is shut. And if that door is shut, how many people are still going to feed the dragon and allow the dragon to run away with its cancerous devouring of the people of the country? The ramifications are huge. And when that happens, then the ultimate is to get an honest monetary system back where you actually own either the paper you're holding or preferably the coin you're holding, instead of getting mere use privileges using someone else's private property, which is what the current Federal Reserve note is.
Robert, what's the importance of attacking the monetary system first?
Well, Gary, I think, is on the line, and Gary understood it very well, that if we're using someone else's property and we're debtors, we have no rights. We're subject to the terms and conditions of the creditor. Gary, you were able to put it very well, and I know you're back on the line because I hear an echo.
So there's no question, but when we are using Federal Reserve notes, we don't own anything. We don't own the shirt on our back, the car. And so you've made the point so eloquently in this presentation today. Obviously, the need now is for all of those people that are listening to us to take the plan to actually learn more. Play this webinar. Again, it'll be up in 5 days and it'll be available, because the information here will save the Republic. It will change what's going on. And it's been carefully thought out.
Ron, show the next slide.
Is there, okay. You can go for it, Robert.
Okay, well, Gary was talking. I just wanted people to see that we're having another 2-day event at the ACAM Hotel in November. We need you there. We can't do this ourselves. We're talking about 50 states here. It's not going to be that expensive to do. The work's already done. There's going to be filing fees in the Supreme Court, but what really needs to be done is get the message out there to the multitudes of people. Gary, you want to continue?
Well, I just have to have everybody understand that Palm Springs, 2 days before ACAM starts its regular meeting, is going to be a repeat of what was done in San Francisco. San Francisco was recorded, and it is able to be purchased, but you need to understand that we have to have you empowered so that when you leave, you understand how these important pieces that Ronald McDonald has found, it is though is the good Lord is guiding him, because we have so much trouble about our rights to treat cancer patients. We have so much trouble about doing things that our medical board wants to frown on. We are being so hassled by the FDA and other federal agencies. And if you are present at the meeting, you will see how the pieces come together. And we found everyone who attended San Francisco signed voluntarily and submitted a testimonial, which I will send to any of you who haven't read it, because I tried to send those testimonials to everyone. Because bottom line, people came thinking, wow, I'm spending almost $2,000. I never spent that much money on anything. And they walked out saying it was worth double or triple that, because it's given them the power to know that we can control this wonderful country that is going into bankruptcy. We know the trouble our country faces. Everybody feels it. Everyone knows it. Few people are willing to say. But as I said, the first thing, the book, if you simply get the book, This Town, and then you realize that we've also had Mark Levin come up with a Liberty Amendments book. That book is flying off the shelves. The Liberty Amendments will take, after we've opened the door with the work you've heard about today, owning those two books, Mark Levin, Liberty Amendments, and Mark Leibovitz, the book This Town. Those two books are going to let you see that we can save the republic, we can bring actual economic sense, and it all starts with having real money, because their money is so totally phony. It's hard for you to believe. We don't even know who actually the Federal Reserve, we don't know what country they think they're going to, we don't know if they're domiciled in London. Nobody knows anything about this Federal Reserve, and yet it's controlling and now destroying everyone's life, because as they point out, they can go into 50 trillion. The numbers are so astronomical, we have no idea what they mean. But we do know
Gary, we have a question, and we're open for questions now. Just send them to me. One of our people has asked, since the United States has reneged 2 times in the past with regards to gold and silver, what makes you think that the federal government will allow the states, meaning the sheriff and recorder, to do what you are suggesting? My answer to that, and Ron will have an answer too, is this is not a federal issue. The federal government has no standing inside the state on property rights. It has no standing. It's entirely a state issue. So if the state forbids the recording of federal instruments at the county level, the federal government can't do it. Am I right, Ron?
Yes, you are. And to take it a step further, as you look at your paper money today, there's no promises on that paper money. There's nothing backing it and no promises. Who to say that since the United States has reneged twice on this, that Congress doesn't pass a law tomorrow making all these notes worthless, even though we have confidence in it?
We know they're trying to do that by trying to get us into electronic money. And if they get us into electronic, quote, money, we're finished. That's the end of your life. There's another question here. What are the consequences of forcing the government to follow these legal tender laws? Will this cause chaos or disruption of commerce? Just wondering what kind of instability will ensue. Not suggesting we pull back, but concerned about poking the giant in the eye with a sharp stick. Ron, you have answers for this.
Yeah, what we're doing is we're not attacking the Federal Reserve note. We don't care. We wish it to continue flowing back and forth until it's replaced by a redeemable note. So that's not an issue in this. All we're doing is a state law that we have to be in compliance with the Supreme Court. The United States has to be in compliance with the Supreme Court. That's all that really matters in this issue.
Well, it could cause, if the door to attack you is closed, and people decide, I'm going to stop feeding the beast, yes, there could be a significant disruption in this country. But the disruption in this country is going to happen sooner or later. I think everyone knows that. And if we keep feeding the beast and it gets bigger and bigger and bigger, it's going to just simply devour everything, and there will be nothing left when it smashes us with its weight. If we take care of it now, perhaps we can go back bits and pieces to restore a constitutional republic.
And the states do have the power of the law of necessity. Let's say that the federal government stops funding every state in the union. The states then have the power under a breach of contract to start printing their own money and getting it out there. Now, the money that is printed in every state could be different, but the values have to remain stable and standard amongst the states. So let's say a dollar in California would have to be equal to a dollar in Nevada, New York, and Texas. So that's an important quality that would have to continue at that point. But we're not suggesting we do away with the Federal Reserve notes. It would drop us into chaos.
It's just that we don't want us to be attacked, and it's our God-given sovereign right that you, that I, that Ron, that Gary can carry on our labor, and we have a God-given, unalienable right to receive something that we own in exchange for our labor. They can carry on with the Federal Reserve note.
Yeah. One of the things is that immediately after this writ is filed, we will be doing a writ against licensure, medical boards, and things of that nature. I would also like to bring up that one of the steps within the state I'm also involved in, it's called Active Liberty Alliance, and it actually will be the process of changing the laws within the state. It'll be a slow encroachment to get our freedoms back from the state. And I'll give you an example of the first one going out there. As far as the bills that travel through the state, no bill that travels through the legislature of the state shall be greater than 10 pages, have but one subject in the title and one object in the substance of the law, and not be written at any greater grammar level than 9th grade.
Oh my God! What happens to Obamacare? I think that was 20,000 pages.
Yes. What about HEPA, Robert? That was 130,000.
Hey, Gary, turn off your mic if you're talking on the phone, please.
Yeah, HEPA was 135,000 pages.
Yes. So I mean, one thing will follow the other. For our attendees, the first thing and the most important thing we must address is the money. That is the most important thing. Next, after that, is we will be filing writs, or we will be preparing writs to deal with the licensure, so that you don't have to fear getting wiped out by the medical board. We don't necessarily have to take out the medical board, although I would like that. I think it's unconstitutional. The issue is you have an unalienable right, and so does your patient, to contract between you for the health care of your choice, even, and we show that in our seminar, even if what you're going to do to the patient might have theoretical risk, yes, the patient can still get it. And we have that directly on point in case law.
Yes. You probably should bring up the worth of the seminar to those who have a business, as far as the gold itself again, Robert.
Oh my God. Well, there's a couple worths here. We had at least 2 people tell us that the seminar was worth at least 10 times the price.
Yes. Yeah.
Just on gold alone, if you were to get those documents and you started transacting in gold coin, you could recover the cost of the seminar in a day or two. That's
But
how
it's
powerful
how you
it
do
is.
that, though. It's important. You have to follow a procedure to do that.
Yes. You have to deal with it correctly if you're dealing in gold coin, and that's one of the things that we will discuss, and Ron would be able to assist you with greatly. So there's several issues, and the cost, it could be recovered in a day or two with regard to that. The cost in terms of your license, the security that you have, the peace of mind, and the means to take care of yourself. Even our attorney friend Walt said that he was absolutely blown away that he doesn't have to go through a regulatory agency.
Yeah, it's a procedure that you follow. Immediately after you get a citation from the medical board, there is a procedure to stop and halt that right there. But it'll continue in another venue. But the thing is that if you have a citation from an agency, they have the ability to use all the hearsay evidence they want. They don't have to prove it. They just have to allege it.
We just got a note. Hope you're aware that the Mark Levin book suggests a very dangerous constitutional convention, plus an affiliation with persons associated with the CFR. Well, if he's doing that, then he may not be the friend that many people think he is. I agree. A constitutional convention is absolutely dangerous. We have a constitution. If it was enforced as it was written, like we talked about, it would be an almost, and I said almost, an ideal document. And I certainly don't want an affiliation with persons associated with the Council on Foreign Relations. Other questions? We're at our 2 hours. Gosh, everybody hung in there. I'm so delighted. Does anybody else have a question for us? Gary, do you have any comments or questions?
Well, I just want to point out that I was present when Mark Levin explained the question about the Constitutional Convention, and if you take the time to really hear his explanation, I think that you're taking the wrong attitude, but you'll have to take some time to really look into it a little deeper, because I am completely convinced that he is not the danger that somebody just suggested. But the bottom line is, if we don't recognize that we have to have some plan as to how we're going to have some structure to solve the problems we're doing, whether you like the book or you don't, it is certainly a basis of starting a meaningful discussion or dialogue. So for 20 bucks or whatever it is, or 11 bucks on Kindle, please get these 2 books. Love it or like it, or leave it. We're going to have serious discussions, and it's a good starting point. He's got a lot of ammunition there.
We will plan, Ron and I will plan to have additional webinars, especially for the people who have attended our meetings, to try to bring them up to speed on everything that's going on. Please consider coming to the ACAM meeting. I mean, come to our legal workshop and then stay for the ACAM meeting. It will certainly help ACAM. And help us get this message out, if you would. Pass it around, because attorneys have seen what we have, professionals have seen it, and everybody who has seen it says, you know, nothing has worked. It's not going to work at the federal court level, but golly days, the states were the ones who created the Constitution, and they have the power to enforce it. They're the ultimate arbiters of this because they were the parties to it, and that's why we believe keeping it in the states, we're going to be successful.
I do think we should mention that I do know that those people where the money is going to prevent them from being there should contact Robert Rowan directly, because special arrangements can be made on a case-by-case basis.
Oh, thank you, Gary. Yes, if money is an issue with regard to our seminar, email me, Dr. Rowan, DRROWEN @att.net. We have somebody who just said that Sheriff Paul in Pinal County, Arizona would be the one to approach with this. Gary, you're in Arizona, so maybe you can go there.
Yes, indeed. And Sheriff Arpaio is in the middle of some hot stuff right now, but Sheriff Joe Arpaio will be very interested too.
Okay. Well, we're going to be ready to move with this as soon as we get some sheriffs and recorders online. So The writ we are willing to circulate to anybody, just to let you know. That is public. The other information in the seminar has to be delivered at the seminar. Any final questions from the attendees?
Thank everybody for staying with us. This is
Final comments from you, Gary.
I just want to thank everybody for coming out on a Saturday and giving us 2 hours of your time. This is not easy stuff. It is worth your playing it again. Please get your family, your loved ones, your attorneys, anybody to play and listen to what you've just had presented. There is nothing weak. There's no weakness in this case at all. It is a good, logical first step to make some sense out of the nonsense now going on in Washington.
Yeah.
We have a question here. Are you referring to the book This Town by Mark Leibovich? I believe you were, Gary.
And
we have another person says, thanks for the effort. It's nice to see others are concerned in taking steps.
I would just say that with the writ, there is no retaliation from filing the writ. You have a public right to promote a public duty. So if you join on, there's no risk to you personally. There is absolutely no risk to you personally.
Okay, how do I get a copy of the SF seminar? We will, you can email me. I will forward it on to the people. The SF seminar is being edited now, and as soon as those DVDs are done, anybody who wants them can order them from somebody in your family is handling it, correct, Ron?
Right, right. Or they can order them through me too.
Give your email, Ron. Let them order it through you.
Yeah.
I think it's important to recognize that because the attendees paid the full fare, that people who get the San Francisco DVDs are going to pay a real price. But I do believe that that much of that money will be credited toward the cost of the ACAM. In other words, if you buy these DVDs, which is going to cost you what everybody paid in San Francisco, I think that you can work a deal with Dr. Rowan that you won't have to pay the entire $2,000 again.
That is correct. We've had several people who came to San Francisco who want to come back. They just loved it, and they're not going to be charged $19.50 or $19.75 again. They're going to be charged a couple $100 to cover food and the hotel expenses.
Plus they'll get, along with the DVD, a USB drive with all the materials on it from the seminar.
Those those materials are absolutely priceless, especially the materials you're going to get on gold. It says, can we file the writ without attending the seminar? The answer is yes, you can. It would be an advantage to attend the seminar so that you fully understand it, or at least get the DVDs. But I think anyone who has seen these webinars and gets the DVDs would understand it, so that they would have no problems understanding what they're doing with this writ. Am I correct, Ron?
That's correct. And also, for every state, there are different codes that would have to be put into the writ for that particular state. So I would have to do that before it could be filed into the Supreme Court of that state.
What we're asking you to do is, if you want a copy of the writ that we've prepared for California, we will automatically forward it to you. Read it.
It's also on my website right now.
There you go.
Wonderful. Okay. Read it. And then if you understand it, take it to your sheriff and your recorder. If they agree to stipulate to it, we will fashion it for the particular codes of your state so that you can just walk into the Supreme Court, pay the fee, and file it. But we want a stipulation from your sheriff and recorder first before we put the work in to tailor a couple paragraphs to fit your state laws.
Yeah. Bottom line, courage. You can't be injured by this, but courage to produce the result we want.
Very good, gentlemen. Thank you so much. And thank you all for attending for the 2 hours. We do have a unique opportunity to preserve our republic from the chaos it's going into. And if you all can't sense the absolute destruction of what remains of our freedoms under the current president and the administration, I shouldn't say the current president, under all of them since Roosevelt, and the speed up of it, then we've really missed the point.
Well, a simple fix for a very, what would you call it, Robert? A very
Complex situation,
Yeah.
a very simple risk to undo the the biggest crime in all humanity was what happened in 1933. Yes, I'm not talking about murders and wars. I'm talking about not a violent crime. When Roosevelt stole the gold at gunpoint of the American people and placed us all in peonage.
He stole the wealth of all Americans.
Because that's where we're at.
Yeah.
Okay, I think I said my piece.
Thank you, everybody. Goodbye
Thank
now.
you, Dr. Gordon. Thank you, Robert.
Thank you,
Thank you,
everybody.
Ron.
Thank you,
Thank you,
everybody,
Lauren.
for joining
Yeah.
today. This presentation will be available for review at www.gordonresearch.com within the next 7 to 10 business days. This webinar is now complete. Have a great day.